Good evening and welcome to Be Informed. My name is Kyle Buhariwala and I founded Be Informed to help people make good decisions. Today we will be looking at contesting wills, and the topic of today's seminar will be how to challenge a will in Victoria. And we're joined by Paul Cott, a friend of Be Informed of Law on Lydiard, who will kindly agree to take us through some of the key tips and traps that we should be aware of when challenging wills. Today's seminar is being presented in Australia, in Victoria, and the jurisdiction of law that applies to this seminar will be the Victorian law. Wills does differ on a state-by-state basis in Australia, and will definitely differ in other jurisdictions around the world. So if you are relying on information from outside Victoria or from another country, please do validate its accuracy of any statements made, because they will not apply directly in your circumstances. The information presented is also current as of today. So if you do rely on this in the future, please do check its currency, because as you all know, laws do change. But I think Paul can probably attest to this. The laws in this space haven't changed for quite a while, so I think it should be okay for the near future. So today's seminar will run as sort of per usual process. Paul will take us through his seminar around about 25 minutes, and then we will have a short little intermission where we will then proceed into Q&A. We'll start off with questions that we received in advance of the session, and then proceed through to questions raised by our participants. If you do have any questions, message me through the chat function, and I will then relay them through to Paul, and Paul will kindly answer them for you. Paul has also prepared a one-page handout, which I will share with registered participants following today's sessions by email. So you'll get a handy one-page document which summarises what Paul has said, and you can easily refer that on to friends and family in need, or keep that for future reference. And sorry, before I proceed, I must acknowledge the traditional owners of the lands on which we are all meeting today, and pay my respects to their elders past and present. So with that all in mind, today's session is being recorded. So if you do join late or have just joined, don't worry, you can watch the full recording on YouTube. Also all our past sessions are available on YouTube as well if you've missed anyone in the past. So Paul, I'll now hand over to you. Thank you so much again for agreeing to present, and I'm looking forward to the seminar. Over to you, Paul.
Yep, thanks for that. If you just bring up the first slide there, Carl. And as you said before, it's a very topical topic. And it is very state specific. So the law doesn't usually change very quickly and relatively slowly over time. But the law in this area underwent significant changes in 2014 to 15. And the reason, or a big part of the impetus for that, was two things. One is that a lot of estate disputes were happening. People were putting their hand up for more under a will or for something when they didn't get anything. And a lot of the time, the money in estates was being eaten up significantly by legal costs. And a lot of claims were being made by all sorts of people. And we'll get to that in a second, where a lot of those claims were actually frivolous, because it was believed by people that it would all be automatic, that, or if I make a claim and it doesn't succeed, that the costs will be borne out of the estate. So that is no longer the case, and that people who make a claim in this area need to be aware that not only may the court impose a cap on how much costs will be allowed by a lawyer and the person they represent, but also will not be automatic, that the cost will be paid out of the estate. And so a person who makes a claim that does not succeed needs to be aware that they may need to pay the cost if their claim is not successful. So, which is a good segue into, am I eligible? The concept of eligible applicant is one of these categories. You will not be able to make a claim, and therefore obviously you will not be able to succeed. just because you're an eligible applicant, and I'll just read out in a second the categories. So the eligible applicant now fall into 3 categories. There is no presumption that an eligible applicant's claim is any stronger because they are an eligible applicant. It is just a hurdle that you have to be able to make a claim, and that is step number 1. So category 1 has certain 1, 2, or 3, you will not be able to make a claim. Category 1 is, and they all they're in descending order of closeness or relationship to the deceased person. So category 1 is a spouse, a domestic partner, as in a direct de facto relationship, or a child or a stepson, under 18, or a student who is 18 to 25, who is a student full-time and or has a disability, and possibly a former spouse or domestic partner who, for some reason, cannot sue under the Family Law Act for provision from their ex-partner or spouse. Then we have category 2, a child, or a very narrow category, a stepchild or a person who believes that they were a child. I'm not covered in category number 1. So that's a very narrow category. Really, in reality, only applies to children. Category 3 is a little bit wider, but still not very wide, and that includes registered caring partner under the De Facto Relationships Act, so that you can actually register your relationship under that act. It gives you some legal rights you wouldn't otherwise have. A grandchild can make a claim, a household member, and a spouse or domestic partner who believe that they were a child if the child dies within 1 year. As I've said, if you don't fall into any of those categories, then you can't make a claim. And with category 3 and category 2, but particularly 3, there is another hurdle you have to get over, even to be able to make a claim successful, and I'll get to that shortly. So in other words, category 1 basically automatically are an eligible applicant. Category 2, yes, but they might need to reach another hurdle, and category 3, they certainly do need to reach another hurdle to get over. Thanks, Carl. The next step is, and these are not necessarily in the particular order that the court will consider things in, but this one is step 4, and I'm reading a lot of these things from a very helpful text. It's written by Richard Cook, who's a barrister. It's called Upsetting Wills. Now, when you see that title, you think that it's a will that's upset people. It doesn't actually mean that. It means how can a will be upset, as in overturned or challenged or, in a sense, amended. Testator Family Maintenance Proceedings in Victoria, 2017. So he says that step 4 is when determining the amount of provision. So is there adequate provision made by the deceased or the eligible applicant? And one of the key things the court will look at is, is this eligible applicant in need of financial support from the will because there has been no provision made or inadequate provision, so not enough. So it might be that the eligible applicant, for example, if they're very rich and have a long and distinguished career, or have had one and going forward, it might be that they're an eligible applicant, but they're not in need of financial support from the will. So even though they fall under the they may not be able to claim under the will at all, which relates to the third bullet point there. Is the eligible applicant able to support themselves adequately without a provision under the will? So that is a key thing. And also, means-tested government payments are disregarded for an assessment of whether they can support adequately. So if there is inadequate provision for that eligible applicant, this could be a factor, among other factors be considered, which we'll get to shortly, that go against or towards being awarded anything, and or may indicate a smaller amount be awarded. As a very rough guide, if, for example, you've got a person in category 1, a child, then particularly if they're disabled, but let's say there's not a disabled child, probably automatically be included. Sorry, they would probably automatically be entitled to be able to make a claim and have some success with it. But as to whether and how much, there's a number of factors that go into it. But the chief one, or the chief starting point, is, has adequate provision been made in the will, and is that person in need of financial support from the will? In other words, can they support themselves adequately, disregarding any provision under the will? And the next slide, thanks. Of course, we're always assuming here that when we're looking at these things, we have a valid will. If we don't have a valid will, then there may be something else, or another process or another hurdle that needs to be gotten over by an eligible applicant. So when I talk about a valid will, it might be that the will, for example, I had a situation where the gentleman drafted his own will, but he didn't appoint an executor at all. So we had to apply for what's called letters of administration. The court was unable to prove that will as a valid will because it didn't have an executor. And the next of kin, the son, was appointed the administrator pursuant to the letters of administration. In addition, a valid will may arise because there hasn't been 2 witnesses signing it. There may be that one of the witnesses is less than 18 years of age. It might be that there are no witnesses. It might be that the will is missing a page, or maybe missing a signing page altogether. And maybe it's just got an initial. So there's various ways that a will can be termed an informal will. So with these lack of formalities being complied with, it is not a strictly legally formal will or formally valid will. And so if there is no valid will, or indeed if there is no will at all, which is another issue altogether, given that anecdotal evidence shows that approximately 40 to 50% of the adult population do not have a will, the concept of intestacy arises. This is not the forum or the venue to go into exactly what happens if there is no valid will to the person's assets. Needless to say, that it just creates a lot of uncertainty as to whom the estate will be distributed to. And I will just say, however, that there is a common misconception amongst people that if there is no valid will, the money from the will of the estate goes to the government. That is not the case. As I've said there, the court can dispense with the necessary formalities to be followed. So, for example, I've given the example which I mentioned a minute ago. The will is witnessed by only one person as opposed to 2 people. It may even be signed and there's no names next to it and no date, so we don't know who's witnessed it. Basically, what the court needs to be satisfied is, despite the necessary formalities not being complied with, is the court satisfied that will validly records the testamentary wishes of the person who's written the will. It's a relatively easy, I guess, to prove, to make a will valid that the necessary formalities have not been complied with. But the issue is, it can often result in legal costs being incurred, which are unnecessary and which could have been avoided if, for example, the person did validly draw up their will, or perhaps should have got a lawyer to draft their will. And I'll just very briefly point out that there are will kits available in news agencies and so forth, and which are probably not invalid in themselves, but the thing is that when it's do it yourself, it may be that you've done these. So yes, as I've said in that last bullet point there, it won't be the case that the formalities are dispensed with if there's a really fundamental error in the will, where, for example, there are no beneficiaries. So I gave the example before of the gentleman who drafted his will with no executor. in a case of where there is an executor and even an alternative executor, it may be that the will doesn't actually specify the beneficiaries, or the writing is illegible, or some major issue with that, then would not be able to be dispensed with those formalities, and it would be an invalid will, and it will either require the court to investigate the matter and have a hearing, and or there is just intestacy, which means there is no valid and there cannot be one. Thanks, Carl. As most things in the law, there are time limits to apply for certain things. Generally speaking, the reason why time limits are in place is because the longer period of time that elapses between something happening and the court hearing, the less likely that witnesses will be able to record the events. In this case, though, 6 months after probate is granted is the time limit here to make a challenge to a will. And if you don't reach that time limit, it's very difficult to have it extended. What you can do is apply to extend time, and at the same time provide the material to the court that shows that it is a valid claim. The court will be reluctant to extend time where they've got no material in front of them that shows it was a valid claim. Otherwise, they risk a situation where, yes, we extend time, further material provided at a later point in time, and there is no, the claim is doomed to fail or would be unsuccessful pretty clearly on the documentation, and then that extension of time was fruitless in the first instance. Courts always have a very wide discretionary power with a lot of things, not with everything. Sometimes things are enshrined in legislation. There's no wriggle room, so to speak, but they do have a general discretionary power to extend the time limit, exceptional circumstances, which requires something out of the ordinary. Something's gone wrong, and the person has not been able to make a claim. So I've given an example there where the applicant didn't know the deceased died. Well, you can't make a claim if you didn't know the deceased died. Or the applicant received incorrect legal advice as to the time limits which apply, which is probably fairly unusual because most lawyers who practice in this area are well aware that it's 6 months after the date of probate. Ignorance of the law is not exceptional circumstances, so that if you didn't know that you could make a claim, as opposed to you didn't know that a deceased died, if you didn't know you could make a claim, that would not get you up if all of a sudden 7 months afterwards you think, well, I could have made what's called a Part 4 claim. I didn't know previously, I know now, but I'm going to make one. That would not get you over the line. And of course, very relevantly, the court will extend time where the applicant has applied in a timely fashion, and or they have an adequate reason for the delay. So obviously, if they've applied 6 months and 1 day after the grant of probate, then it's much more likely to be granted than if it's 6 months and 1 year after, and obviously the longer period of time. In the absence of a pretty compelling explanation for the delay, they would not extend time. And of course, only where the estate has not already been fully distributed, because there's nothing left to claim against. So that's something that executors, if ever you're an executor under a will and you're administering an estate, be aware that you must wait 6 months, or generally have to wait 6 months after distributing the estate. If you start to distribute the estate, some of it, or a lot of it, or all of it, and you, in other words, you pull the trigger too early, somebody makes a claim, and all of a sudden everybody realizes that half the estate or whatever has been distributed, and there's nothing left, or not enough left to claim against. So, for example, there's $100,000 left in the estate, and now we've got a Part 4 claim for $200,000. There's not enough left. That can make the executor liable. So, if you are an executor under will, it's a very important task, and I would seriously consider getting legal advice, because executor, if you distribute early or distribute resulting in the estate having no money left, the executor can be personally liable. Thanks, Carl. So the list of the things that the court will consider are very long. So one of the factors to whether somebody make a claim and it will be successful is did the deceased person have a moral duty to provide for the claimant, or a moral duty to provide more than what they did? So the very first principle is what's called freedom of testamentary capacity, which means that a will maker is entitled to um, gift their estate to whoever they see fit. If they wish to distribute the estate, which I am aware of, one I did recently, to 6 charities, and leave all their families out, they are entitled to do so. However, the court then brings in this concept, which is in opposition to that, called a moral duty. Did the deceased have a moral duty to provide for people who would have had an expectation of an entitlement under the will? Category 3 claimants, what we talked before, may also need to prove that they were financially dependent on the deceased. And secondly, the person needs to prove that adequate provision was not made for them. So the factors there in bullet point 2 are non-exhaustive, but they are the main ones. So the size of the estate would definitely be relevant. If you've got a small estate, for example, worth 60,000, and you've got 3 beneficiaries, and and there's a 4th person who's putting their hand up, well, we're going to be either dividing it 3 ways or 4 ways. So that might point against, particularly when legal costs are factored in as well. If it comes out of the estate, that might be a factor against allowing a 4th that claim of that claimant. As I said before, whether the deceased had a moral duty to provide for the applicant, the conduct of the applicant in general, how they conduct their life, but also towards the deceased. So, for example, there are many cases where a person doing their will says, well, I haven't spoken to my son for 20 years. He broke the relationship off. I've written to him. I communicate with him. He's never responded to me. I'm aware that he's a drug addict. He doesn't work. He beats his wife up. All these types of things, um, even though they're relevant, that will not necessarily disentitle that son, who would be a Category 1 claimant, to anything under the will. The issue then would become how much that son would be provided or awarded by the court. The applicant's financial needs is very important. The applicant's health and disability. If they have a disability, there's been large awards made by the courts in cases of person who are disabled to such an extent that they cannot ever work again. The financial needs of the other beneficiaries. So if there are beneficiaries in the estate and they are potentially all or some of pressing financial needs, then it may be that is a factor to say that they might be able to maintain what they are getting, or even to oppose the claimant getting anything at all. So the other beneficiaries are definitely factored in. The age and the well-being of the eligible applicant. Probably it's true to say that the younger the eligible applicant is, and the more a long life they have ahead of them, with all the financial needs that arise over time, it may be that they get more, as opposed to, for example, 79 years of age, they might not need a great deal of financial support from that person's will. Obviously, whether they work or not, what their income sources are, what the amount of the income is, and there is an overarching category, anything else that the court sees fit to be considered, anything that we haven't mentioned, or anything that's not in the explanatory memorandum to the legislation that comes up in a particular case. The law can't provide for every type of case. So basically, as I said, the lists of the other things that the court considers are basically endless, but with the 4-step process in place. And I'll just take you over that again now. Step 1, is the person an eligible person? Step 2, has the application been made within time, so 6 months after the grant of probate, unless it can be extended. Step 3, have the basic conditions of the legislation been met? did the deceased have a moral duty to provide for the claimant at the time of death? And does the will fail to make adequate provision for their proper maintenance and support? And if they are all successful or the hurdle has been gotten over with in respect to them, step 4 is where there is a long list of factors where the court will consider the amount of any provision. And I'll just give you a few more examples of what the court will consider. The nature and length of any relationship between the deceased person and the applicant, what the applicant might have done to build up the size of the estate of the deceased person, any contribution by that person either in financial means, or in respect of looking after and directed towards the welfare of the deceased or even the deceased family can be relevant. Any benefits given by the will maker previously. So if the will maker has gifted the eligible applicant $100,000, for example, 1 year before the death and before a claim might be made, then that would certainly be taken into account by the court. And whether and to what basis and to the extent was the claimant actually financially dependent on the deceased. So did the deceased maintain or give them money throughout their lifetime or of recently? The responsibilities of anybody else to maintain the claimant. So if the claimant is a wife and she has an income which is a family income and the husband supports the family, that would be taken into account. And as I said before, the conduct and character of the claimant or anyone else, the effect that an order, if made, would have on the other beneficiaries, which I've mentioned, and as I said, the very last category, anything else relevant. Thanks, Carl.
Thanks, Paul. Paul's details are on the screen, so we thank him for presenting the seminar. So if you do have any questions about the material presented by Paul today, please do reach out to him. I think, as he mentioned, it's not a sort of a straightforward area when challenging wills and going through the probate, executor, all those processes. So it is something that you should seek advice on to make sure that you, I guess, do it correctly and have a good chance of challenging the will if you have a case. Just a reminder, this session is being recorded. So if you have joined late or need to leave early, you can watch the entire session online on our YouTube channel. And Paul's also prepared a one-page handout, so you can refer to that following today's session. I'll send it through to registered participants by email, so you don't have to take a long amount of notes. You can rely on that handout and share with family and friends if you need. So for Q&A, please do send through your questions via the chat function. I will relay them to Paul. But Paul, we'll start off with some of the questions we received ahead of time. So the first one being, I think from an administrative perspective, Paul, what does someone have to do? What do they have to do when they want to challenge the will, right? Like what's the administrative step? Can they self-serve? Is this a sort of a system they can do online, or should they engage a lawyer to sort of help them through that process? Like, what are sort of those initial steps they need to think about?
I think the first step they need to do is to see a lawyer, because if they're not an eligible applicant, then they can't make a claim. It'll be a waste of time and money to do so. Probably the first step would be, and it does relate to the next seminar I'll present in just over 2 weeks, in that see that lawyer. The lawyer may write a letter of demand setting out why they say that adequate provision was not made, and setting out what provision should have been made and why, in reference to the legislation. And if that letter of demand is not complied with, or it's not agreed as to what the claim that's been made, you might try to avoid litigation and suggest an informal conference between the parties. So it's sort of like a mediation but not court annex mediation to see if you can resolve it before issuing proceedings. It's probably fairly rare that I advise people that they should go to court these days. So good to try to resolve matters earlier rather than later by what's now called early dispute resolution and not alternative, because the alternative way to resolve disputes now is court, and the main or the early resolution is mediation and informal roundtable conferences, negotiations, and the like.
Yeah. No, that's important, isn't it? I think without that guidance, you don't really know what steps you can take in this area. So I think getting that support.
Well, that's right, and also if once the paperwork is lodged to the court, it's got to be pretty technically spot on. It's got to be in the right format, comply with the court's procedures and the rules, and you sort of really got to know what you're doing in terms of those steps. And that's not to say that a savvy person who's not a lawyer couldn't make their own claim, but I think that would be the exception to the rule.
Yeah.
Yeah.
Fair. Okay. Another question that we've got, Paul, is, and I like the way this person is thinking. We talk about eligible applicants. What about adopted children and those that are not sort of directly, I guess, I know we talk about financial dependence and there are other tests that apply, but do you have any experience in this space, or do you know what the answers would be if it were to be children that have been adopted or there's no direct birth link to the deceased in case of dependence? Do you have any thoughts on that?
It's a good question. It's not something I've dealt with, but I would say that they, depending on how long they've been adopted for, and if they with the deceased person as their child, then they probably come under category 1.
Because you see a lot of
child of the person.
Yeah.
It doesn't say biological child.
Yeah, this person's query was sort of they're a foster carer, and just wondering, what potential future ramifications may occur down the line, in terms of making adequate provision, I guess. But yeah, it's I guess there are various other tests rather than just the biological lineage and all those sorts of things that need to be considered for eligibility.
Yeah. Well, as far as I can see, with the short extracts from the legislation, I'd probably have to look into the legislation and see if there's a definition section in the Act that has a definition of what a child is. But I would say that it's likely that the court would treat that person, depending on how long they've been living with the parents for, so to speak, that they would be a child.
Yeah. Yeah. And thank you. Yeah. So another question that we've got is around I think this links to the adequate provision, sort of component that you raised. In your experience, when as you know, Paul, it's probably hard, and what this person's trying to get, it's hard to put a dollar figure on most things, right? A lot of the times it's driven by market, economics and forces and all that sort of thing when you think about goods and services and how things are priced. But when you're trying to put a price on whether someone's made adequate provision for a beneficiary or one that's not listed, like, to what extent is the onus on the person raising the challenge or mounting that challenge, right, or submitting the challenge, right? What extent is the onus on them to really go through that analysis and prove why they believe it should be X amount or X percentage? Is there a heavy evidentiary burden on the person making that on the challenge?
Well, if you start a court case, then the general rule is that as a plaintiff or an applicant, the burden of proof is on you on the balance of probabilities. By the way, you don't have to prove it to the 100% degree or even the 99% degree, or don't have to prove it like beyond reasonable doubt. But the onus of proof is on the applicant. to prove the elements of their claim. On the other side of the court, on the other side of the coin, the court has a very wide discretion, and the applicant can say, well, I think this is how much I should be awarded, and the court uses their discretion to choose a different figure, and the court will hear from the lawyers for the estate and the lawyers for the applicant, and they will obviously be recommending to the court that different figures be used, and then the court will have to make the decision in their wide and unfettered discretion. So it's not really possible to prescribe any rules about how that is made. It is just all those factors go into the wash and it comes out.
Yeah. And Paul, one question that we received in the chat function, I think you mentioned, the rule where you have to wait at least 6 months before the executor should start distributing the estate. Just a follow-up question on that. If it has been distributed and, there's a challenge, is the individual barred, or can there be remediation sort of attempts to rectify where I guess their estate should have been distributed to and people are then obligated to repay, or, you get what I'm going with this, but is there any power within the courts, I guess, control to do that sort of thing and require people to make remediation, sort of efforts, or once it's distributed, it's distributed and it's pretty much, that's it, nothing can be done?
Well, the remediation can be a claim against the executor for using the discretion that they have wrongfully. The executor is potentially up for personal liability.
Right.
Early, a claim came in, the estate's been exhausted or distributed, there's nothing left. It's on you, Mr. Executor or Mrs. Executor. That's why executors really need to know what they're doing. And so there are a lot of guides around online. I actually had one myself, just trying to think where it is. It's a really good guide to executors because there is a potential that remediation will come out of the funds of the executor.
Right.
So that's why it's a really pretty strict rule. Don't distribute all of it. I mean, for example, and it happened to me. There's an estate worth 500,000, and I say to on one of the beneficiaries among two others, I need an advance on my estate. I need to buy a new car. My car's just died. Here, Paul, you have 10,000 now. This is an advance on your estate. That'll obviously be deducted when you deducted from the amount you're going to get in the end. And that's a decision that can be made because there's still $490,000 left. So even if there is a claim, there's still going to be something there.
Right. I think that's quite an important point you raised around the obligations that the executor has when administering the will and the estate.
Yeah.
It's probably pretty wise that they engage a lawyer to guide them on that journey. Otherwise, if you say there's personal repercussions, then you don't want to make mistakes.
It's a serious role, and an executor, it's a voluntary role. So I always tell somebody who's doing their will, who do you want to appoint as the executor? And they name the person. I say, you have to make sure that person they want to do it. Because some executors might say, no, I don't want to do it. I don't want the administrative burden and the hassle of having to go to the bank and close bank accounts and all the various administrative duties. And there'll be the rare case, admittedly, where an executor will say, no, I'm aware that there is potential for personal liability in me and I don't want to risk it.
Yeah.
And so the executor might say no. Not only that, but the executor can change their mind. They can what's called renounce their appointment. And say after the event, I've seen a few cases of that.
Yeah, right.
Where years down the track, although rarely before the person dies, that, hey, I've changed my mind. I don't want to be a part of this anymore. I'm of ill health now. I can't get around to banks and so forth. I'm going to renounce my appointment. And you have to do it formally. Renunciation of probate. Or if probate's been granted, or renunciation of executorship. So it's a serious role that it's voluntary, and you can't have it imposed on you.
Right.
Also, executors can die,
Yeah. Or
and
become
then
incapable.
if there's no alternative executor appointed in the will, then the court.
Right. Interesting. Yeah. I think that's sort of a bit of an added benefit of that remark. I think is just, yeah, if you are an executor, understand what your obligations are and seek the necessary guidance so you don't make a mistake. All right. We just had another question come through, Paul. You mentioned the list, that it's quite in terms of in terms of the factors that challenge, the factors that the court will consider when challenging the will. This is those factors on that slide, and then the court has sort of a catch-all provision at the end. The matters that it sees fit. In your experience, how creative do some individuals get when challenging the will? You can imagine there's a large estate, everyone wants a bit of a pie. I know they have to prove that they're an eligible applicant, but with that, they also need to prove the other components as well. Have you seen any sort of interesting, sort of thoughts made around those points around challenge?
Nothing. Usually, the factors that are considered are the usual ones, which I listed, but most commonly it is to do with issues of estrangement and issues surrounding that, where their will, or even changing their will to put somebody out of it, as opposed to where they were in it before. That's usually been the common issue, and the financial need of the applicant is a big one. As far as creative ways to slot into that category of anything else relevant, I don't think I've really seen anything in that category. It's all really been under the financial needs of the applicant, issues to do with estrangement, disputes as to whether the applicant did in fact visit mum every week for the last 10 years. And then the sister says, no, well, mum told me that she hadn't seen you for 5 years. That's the most common one, but as I said before, that the fact that there is estrangement does not necessarily disentitle you. It may, but it may not mean that the court will award you less or nothing. But that generally, if you're a daughter or a son or a spouse of a deceased person, you will get something. The issue will be how much.
Right. Yeah. So that's comforting to hear that people are not sort of using that to abuse the process. I think, with wills and these types of processes that happen following the death of a family member or a friend, and there's always usually some of those elder abuse that might happen beforehand, before the person passes away, and sort of good to hear that in your experience there hasn't been too many individuals using that sort of catch-all provision as a gateway to their
That's right.
freedom, I guess.
I mean,
All right.
the law is preventing a lot of people or has prevented now a lot of people who formerly, I mean, I remember 10, 15 years ago, I used to often hear a story about how a neighbour's made a claim under somebody's will, or I don't know whether it actually happened or not, but it was often talked about, well, the postman made a claim under the will because he delivered the mail there every day and they'd have a chat. and the lady would invite him in for a cup of tea, and even the garbage men, you know, silly things like that.
Yeah, you're
That's
right.
how it was
I have
getting
heard of those
abused.
back in the day. Yeah, it's not. It wasn't uncommon.
That was how it was getting abused. There's
Mm.
all these and friends who, oh, I used to go and visit that person 5 times a week, just that nobody ever saw me come and go, but I was there every day. And it's a friend. Friends can't claim anymore. They're not even in category 3.
Mm. Yeah, I think it's important that that happens so that there's a
So even
bit
if,
more rigor, yeah, around the distribution, right? Otherwise, it's just those truly entitled to it have to then have this, have to deal with frivolous, I guess, claims
yeah,
by
and
individuals that have no sort of
the
money.
eligible applicants, so it's a bit slow, so I'm thinking he's talking and then he's still going.
Yeah,
The eligible, apart from old, they're nearly all family
yeah,
now. You know,
yeah,
which is a big difference because before it was almost a free for all. If you looked after someone or visited them every day, or even gave them money, or they lived off your income, or you gave them a lot of gifts, or you put money in their bank account every week. All those things alone don't mean anything now. If you're not an eligible applicant, then you're out. Simple as that.
yeah, yeah, yeah. No, just thank you, Paul. That's all the questions we've got. I'll just share Paul's details on the screen again. Paul works at Law on Lydiard, principal lawyer there. So if you do have any questions, just contact him directly. More than happy to help you. So that's been the seminar for today, how to contest a will, of course, with the Victorian approach. As I mentioned, this session is being recorded, and a copy of the the recording will be made available after today's session on our YouTube channel. Paul's also prepared a one-page handout, and I'll share that with registered participants by email, so you've got that document handy. Please do follow us on social media. We do rely on word of mouth to help be informed in the minds of everyone that we can. So if someone that will find interest in these seminars, then please share it with them. And Paul's also joining us in 2 weeks here. He alluded to the next seminar, which will be around how to resolve a business dispute. We have had a lot of inquiry about that one. So, just getting that process started and knowing how to take it to the next level, I guess, is something of interest to those in our community. So if you also might think that might help you, then please register for it. Paul will be joining us on I think it's the 13th, is it?
13th.
13th?
13th.
Yeah, of March.
Yeah.
Same at 6 o'clock on a Wednesday to take us through that one. I'm quite looking forward to that. And that brings us to the end. So again, Paul, thank you for your time. Always a pleasure, friend of the group. And wish everyone good night. And enjoy tomorrow. It's the 29th. It's a leap year, so auspicious for some. Make
That's
the
right. We
use
get
of
an
an
extra
extra
day this
day.
year to, yeah.
That's it. Do something. Yep. All right, Paul. All right, everyone. Thank you so much for your time.
Thank
And
you.
bye for now. See
Thank
ya.
you.